And thank you for joining our monthly Peapack Private Planning webinar. I'm Claire Toth, here with my colleague Elaine Phipps, and we're particularly happy that you're here with us on what's been the nicest day of the year so far. You could be outside taking a walk, and here you are talking about estate planning. I'm going to turn it over to Elaine in just a moment, but we do have a poll question up, so please answer that. We'll review the responses at the end. If you've got questions, please use the Q&A feature at the bottom of the screen, and we'll address your questions at the end as well. Elaine?
And just in case you happen to miss something, be assured that we will be sending out the replay link to everyone at the end of the call. We will also be sending out a financial organizer, which will bring together many of the things we're talking about today. So you'll have some homework to do. All right. Well, thank you for joining us. And when most of us think of estate and end of life planning, we tend to focus on the will, who gets what, and then who gets nothing. So once you're gone, that's not really your problem. We believe you should be more concerned about when you're still around but need help with things. So today we're going to speak about mechanisms you can use to make financial and medical decisions easier for you when you're ill or incapacitated. This will also make things easier for your dependents, family, and your heirs. So these things include the healthcare power of attorney, the financial legal power of attorney, revocable living trusts, and other options such as guardianships, payable on death, and joint accounts. Okay, so let's move on to the healthcare power of attorney. This is a powerful document, and it does basically three things. First, it states your wishes for end-of-life care. It also appoints a healthcare proxy to speak for you when you can't. And then finally, it gives directions for medical personnel to release healthcare info to that proxy.
And let me just jump in and add, sometimes this is all one document. Some attorneys will prepare 3 different documents, but regardless of the number, they'll all cover these 3 things.
So the healthcare power of attorney covers terminal, serious, and irreversible conditions if you can't communicate. Most healthcare power of attorneys tend to be general about the level of care focusing on interventions, nutrition, and hydration. You know, this document is often prepared when you're younger and don't have a specific medical situation to deal with. So it's fairly difficult to envision the planning. Some plans are very detailed, and we've had clients who like that and find it helpful. We have some clients who find that overwhelming. You know, they don't want to think about an event out in the future. So it's hard to say several years out exactly what you'd really want if you were in that situation or had a terminal illness. So in a few moments, we will compare this to the PULSE document, which is a physician orders for life-sustaining treatment, or also known as a portable medical order. And that is a more specific medical but not legal document, which can be helpful. Your healthcare proxy cannot overrule your wishes in the healthcare directive regarding end-of-life care. We read a lot of stories about this. It's a delicate matter, but if you have said no ventilator, those wishes should be legally honored, even if family members have a change of heart. The healthcare power of attorney also should direct medical personnel to release healthcare info to not only your proxy, but also anyone else you stipulate. So remember, we now live in a HIPAA world where, you know, having the correct paperwork in place before a doctor or nurse can speak to anyone is very important. So if your husband is your POA, but your kids across the country want info on your condition, this document would help facilitate that if that is what you would like. So that should be spelled out as well. Okay, so after you've prepared the document and signed it, what do? You have a copy, your lawyer has a copy. The POA should be given to your primary care physician, and you should get a hold of some of those wallet cards, which you can carry in case you're in an emergency or accident, And they usually say, my power of attorney is here, call this person, call that person. I have one in my wallet. And then finally, if you don't have anyone to appoint as your healthcare proxy, be aware that you may in the future be given a court-appointed guardian. This is not the preferable course of action, so hopefully we all try to avoid that with the planning. Okay, so this is a detailed chart, which we'll just touch on briefly, but you'll have in your replay. The two advanced care planning options are the advanced directive versus the POLST. So both of these you should consider as part of your care planning. The POLST is not a legal document, but an agreement with your doctor once you have a specific diagnosis. The provider will go through the actions for managing this illness with you. The plan should be very detailed and have specific medical orders, which your advanced directive that you did years ago might not have. Remember, that AD was put in place before you even contemplated being in this situation. So, we would hope the POLST is used as the standard of care for this illness and to implement your wishes for the remainder of your life. You should be aware, though, that the Healthcare Advance Directive, POA, because that's a legal document, can override your wishes in a POLST. Okay. And then finally, the DNR. So the emergency do not resuscitate orders, they're not always addressed in the healthcare power of attorney. The DNR is really a medical instruction signed by you and a physician, and it's for emergency situations. So the emergency personnel must follow that order in specific instances of cardiac and or respiratory arrest. So it really just deals with those situations in a critical moment. So think of this as a situation where you are in a car accident or EMTs are summoned to your home in an emergent situation. In addition to one for the EMTs, there are also institution-specific documents. I needed a separate one for a family member, both for the hospital she was at, as well as the rehab facility she went to. What do you do with this document? It should be on your refrigerator, in your freezer, just put somewhere that you know where it is, along with your healthcare POA in home in case emergency responders come. The last thing you really want to happen is if you or your loved one do not want to end up on life support, is to have the EMT undertake those measures because no one can find the DNR. No one is thinking clearly during an emergency situation, as I know this happened in my family.
And let me just throw in that EMTs are trained to look at the refrigerator and in the freezer. It's the default place to keep it, however silly that may sound if you haven't been in this situation.
Did not know that. Okay.
Yeah, absolutely. And I am told our poll is going live now, so please look for that. So going to
I'm going to pass this on to Claire to get into some of the financial and legal POA.
powers of attorney. Everybody needs a power of attorney, and this allows a person called your agent or your attorney, think of it as your spouse or your adult child, to be able to represent you across the board. And that's not just paying your bills and getting into your bank account. It's claiming pension and insurance benefits. It's filing your tax returns, if you're audited, being able to represent you there, collecting debts you owe, paying debts you owe, that sort of thing. And certainly the person who has your power of attorney can conduct financial transactions in your name. If you've ever done this, you sign your own name and then POA afterwards to represent it. And you tend to think of powers of attorney for when the adult has diminished capacity, really can't run his or her financial and legal life anymore, but they have a variety of uses. Remember when people used to travel? Hopefully that will happen again. If your spouse is out of town and a document needs to be signed, you can do it with the power of attorney. And finally, to note that Social Security is the one government organization that will not accept a power of attorney. If the Social Security recipient really can't manage his or her own finances and you need to make changes. Say you need to change the bank where the money's being deposited, you want to change the tax withholding, something like that. That requires an in-person visit, and it's long and complicated. So as we will get to, I recommend that people set up online accounts at Social Security, and that's a much easier way to manage that situation. There are different kinds of powers of attorney. People are often very concerned because if you sign what's called a durable power of attorney, that's the preferred one, it's immediately enforceable. Your adult child can go run to the bank with that. And so for that reason, many people are concerned about them and ask about what's called a springing power of attorney. The springing power of attorney becomes effective only when the principal, the person who signs the document, in this case you, is determined to be incompetent. So it really requires going into court to get that declaration before the power of attorney is valid. And the whole point of a power of attorney is not to go into court. So we really do encourage people to use a durable power of attorney. That doesn't mean you have to hand it to your kid today. It should be readily available if needed, in a safe place in your home. Your attorney will have one, so that your child or other person or friend can access it if needed, but doesn't necessarily have it from day one. One of the things with the power of attorney is it's very easy to revoke. For example, I was a power of attorney for a family member. She lived across the country. I really just wanted to watch the bank accounts to make sure she was paying her bills and wasn't getting scammed. And she was the kind of person who would walk into the bank every week, have a long chat with the teller while she took out her grocery money. And one day she said, well, I don't want Claire to be able to sign checks on my account. And without meaning to, she revoked the power of attorney. I was no longer able to see what was happening with her financial accounts. So that's one concern about them. Another concern about powers of attorney is many financial institutions don't like them. There's a lot of concern out there right now about elder abuse. Much elder abuse is done by family members, and the power of attorney comes up very frequently in these. So banks and other financial institutions can make it difficult to operate with the power of attorney. As an example, for another family members, husband and wife, I was on their account at large multinational bank as their power of attorney. She passed away, and all I wanted to do was take her name off the account and retitle the account in his name. And he was the primary account holder in any event. And this particular bank made me go sign a whole new set of documents, get them notarized, get a letter from his doctor saying that he wasn't capable of managing his accounts by himself, yada, yada, yada. I went through that whole process, and the next day I moved all the accounts to a smaller, friendlier bank that was easier to work with. The alternative, if you don't have power of attorney, is to get that court-appointed guardian. We see this most often with people who don't have immediate family members. The courts tend to have a roster of attorneys who they'll appoint as your guardian. And hopefully that attorney does a good job. He or she has to make annual reports with the court. There's going to be a fee for all of that. It can get expensive. So you certainly should have despite the drawbacks, there needs to be a power of attorney with somebody close to you you trust. In addition to and expanding upon a power of attorney, a lot of people should be considering, they're called living trusts, revocable trusts, they're the same either way. Many people think of these as a will substitute, because after person who sets one up passes away, it generally has most of the operative things, who gets what. However, I think they're really most useful when you're still alive and you need a little bit of help. When you initially set up a revocable trust, you're the person who puts the assets in and sets it up. That makes you the grantor. You are, so long as you're compos mentis and in charge of things, you are the trustee of the trust. And while you're alive, it exists for your benefit. So you are wearing the three primary hats in the trust. However, the trust can be set up so that you can appoint somebody else to be a co-trustee to work with you, or you can resign in favor of somebody else to take over your accounts if you cannot. And as much as banks and other financial institutions do not like powers of attorney, they see a trust, they just go into operating mode. They know what to do. And it can be much easier to operate somebody else's financial life, pay the bills, move the money, get the deposits. You as trustee of the revocable trust than using a power of attorney. However, the revocable trust only covers the assets that are retitled in the trust's name. They don't deal with the other legal aspects of your life, so you still do need a power of attorney. Many people will set up a revocable trust, or at least sign the document, and not put any assets in there. Then your spouse, your friend, your adult child can use the power of attorney and move the assets into the trust if needs be. That's an option. It can be cumbersome, but it works. And then, although we're primarily talking about what happens, while you're with us, the revocable trust does have a lot of functions after death, as opposed to a will. First, they don't save taxes. We're really not talking about estate and inheritance taxes today. Happy to talk about them another time. But as far as the tax authorities are concerned, you and your revocable trust are one and the same during your life. So you're not getting around anything there. However, there are states where probate is either lengthy and cumbersome or expensive or both. For those of us in New Jersey, the good news is that's not the case. But California, New York, Florida, they have very cumbersome probate procedures. We found out the hard way that New Hampshire can be a really expensive place to probate a will. So depending on where you live, you may want to use a revocable trust for that purpose. If you own property in a state other than the state you live in, and you own it in your own name at your death, then there has to be probate in that state as well, to transfer title. So a lot of people will put the vacation home in the revocable trust or some other vehicle that will avoid setting up ancillary probate. Wills are public documents, trusts are not. So if there's something in there you don't want to be made public, maybe you have a child who needs to be protected financially, whether for mental health or substance abuse reasons, something like that. You don't want that necessarily in your will. A revocable trust might be the way to go. And finally, there are states, New Jersey tends to be one of them, where if you pass away, your name's on the financial account. The account is wholly or partially frozen until a bunch of returns are filed, even if no tax is due. Those sort of laws typically do not apply to trusts. Every state is different on this one, so you'll want to check with your estate planning attorney, but that can certainly make it easier to access funds in the immediate aftermath of a death. And I'm going to hand this back to Elaine to talk about some do-it-yourself alternatives.
Okay, so there are some other options to the living trust Claire just discussed. With the payable on death or the transfer on death accounts, immediately upon the death of the account holder, the assets will go to those designated on the specific account. So your beneficiaries on the accounts can go into the bank with a death certificate and take their share out ASAP. It's not dependent on what the other beneficiaries do at that time. But this may also result in different beneficiaries getting different shares of your estates. If you put son A on bank account A and son B on bank account B, and they're different size accounts, things could get a little bit complicated. The positive to your beneficiary is they get the money quickly. They don't have to wait for probate or the estate to be settled or the account to be frozen for tax payments. The negative is we have seen situations where all of the money is paid out to family members at death. They're very happy, but then the executor has no funds left to pay the necessary bills, the final mortgage payment, the funeral. So funds are needed for that. The executor might need to have to go out and reach out to the family members who may or not be able or willing to chip in. So logistically, it could be a bit challenging. The joint account works similarly and can help facilitate bill paying, especially if it's a small joint checking account you set up. Keep in mind, though, if it is a larger, over $30,000 account, it is considered relevant enough to file a gift tax return. So even though you view yourself as the primary owner, the IRS views it very differently. You also need to be careful and make sure you trust your joint owner, as they legally, perfectly legally, could empty that account should they choose. So probably best to not use this type of mechanism on an account that is the bulk of your assets. And should the joint owner run into legal problems or declare bankruptcy, the assets in this account can be subject to outside creditors. So here you are thinking that this money was safe and was going to be used to nurse you in your illness or old age, and instead it can be locked up in litigation. So just a couple things to be aware of. Claire?
Okay, so we're talking about all the ways that your family members, your close friends can help you should you need it. And let's also talk about making it easy for them to do so. This does kind of tie into our little polling question. I do ask folks, if somebody had walked in your front door and had to take over your financial life for you, how hard would it be for that person? Many other attorneys, accountants, all have what are called financial organizers that we give to folks. We'll send them out to each of you. You don't have to use that. You should have something, and it should be in paper, that will get that person started. Who do I call? Who's my lawyer? Who's my accountant? Who's my insurance agent? Where's my bank? Where's my safe deposit box? What are the primary accounts? And even I shudder to say, how do I get on the computer, and what are some of the account numbers? What's the login information for some of the primary accounts there? A colleague of mine had a client pass away a few years ago who was an IT exec. There was no paper. Everything was on the computer. Nothing was written down, including the password to the computer. And the family ended up having to hire a professional computer hacker to get into the machine so that they could begin to figure out what the assets were, how many there were, and collect all of the information. That's not something we want to put our family through. And again, if we're talking about us during our lifetimes, we really want to make it easy for people to help us and keep us as comfortable as possible. So that's pretty much it for now. We look forward to speaking with you. We're going to turn to some questions. We'll get to the poll in a moment. I will say we got some questions in advance of this webinar asking about potential tax law changes and steps we should be taking now. And I'm happy to address those separately offline, but here we're really focused on the nuts and bolts of helping you when you need help with your finances and your medical care. So let's turn to the first question. And that's if I have my parents' online access information to the accounts, I mean, do we really need all these documents? And the correct answer is yes, you do. Impersonating somebody else online is at best a gray area, though you could certainly be acting as that person's agent. Again, this is a state by state thing. I know in New Jersey, the law says that the person with your power of attorney, the trustee of your trust, your executor, is allowed to have online access to all of your accounts, financial, social media, all of that, but only if the documents say so. So you need the documents to say so. And finally, particularly again with financial institutions that are very concerned about elder abuse and diminished capacity, I've seen this one happen where the bank or the brokerage firm realizes that a person does have diminished capacity and then freezes all the accounts until somebody produces a power of attorney or trustee of a revocable trust or goes to court and gets appointed the guardian. And again, that's not something you want to do. Next question. Can a revocable trust have joint ownership? Can a husband and wife create a revocable trust together? And the answer is yes. This is one of these things that varies. As a practical matter, it varies from state to state. California, which is a community property state, that's the norm. We see a husband and wife creating a revocable trust together to hold the assets. I've seen it in New Jersey, though not frequently, the same for New York. So a lot of that may be how the lawyer tends to set things up. Just mechanically, with my wealth management hat on, it's a little more cumbersome to retitle accounts into the name of a joint revocable trust than individual revocable trusts, but that's just a one-time hurdle. It's not that big a deal. But certainly a revocable, the husband and wife can each contribute half of the house to the revocable trust. Alternatively, in most states, the husband and wife own the house with right of survivorship. So at the death of the first spouse, the second spouse automatically owns the entire house without further action. And that may be the time to put it into the revocable trust. That's sort of a matter of personal preference. So do we have, I'm not seeing further questions. I guess Elaine, we've just awed them with all of our war stories about this.
Or they don't want to think about the things we discussed, maybe.
Okay, so I will say I got one more question, but so I applaud our audience because everybody thinks that somebody could step in for them. About a third of you say that you are well organized. Somebody could come in and get your information. And about half of you think, yeah, it could be done. There's only a couple of you who have some work to do. How do you research an estate planning attorney? Ask for recommendations. And there are a couple of other options. There's an organization called the American College of Trusts and Estate Council, or ACTEC, ACTEC. You have to be elected to this. It requires several years of practice in the estate and trust world. You've got to be recommended by your peers. So attorneys who belong to ACTEC tend to have some, a lot of experience under their belt and are well thought of by their peers. So that's a good place to look, particularly if you're looking, say, for an attorney for your parents who live in a part of the country where you don't have contacts. What if you got a question about what if you go into a nursing home, or you want somebody, you really want advocates in that situation. So you want to be sure you've got the power of attorney and the medical directive. So you've got people speaking up for you. How much should one budget for a revocable trust? It's really not a whole lot more expensive than just the typical will, power of attorney, medical directive. I mean, maybe another few $100s on top of it. But with any getting the estate plan written and set up, the biggest cost is the information collection that the estate planning attorney is going to do. Most of them will give you forms to fill out. Here are all my assets. It's another reason why you should have an organizer. Makes it much easier for that form to fill out that form. You should have a pretty good sense of who's going to get what. But the actual document production is the least of what the attorney does. It really is the counseling, the information collection. And if you go into the discussion knowing that you want a revocable trust because you've done your research about that, then you've saved that whole conversation. And boy, this is fairly speedy, but I guess it's because everyone wants to go out and enjoy the 50-degree weather. So we thank you. I know questions will come up, they always do, so please reach out to us. And we will send you the link to the replay on this, along with our financial organizer, although it looks like 2/3 of you don't need it.
You can pass it on to a friend.
That's an excellent idea. Thank you, Elaine. And we look forward to speaking with you in the near future.
Thank you for your time today.
Thank you.